which every Israelite American became through unwitting acquiescence, thereby placing them under privilege of such citizenship, and also allegiance to and subject under the laws the same. Case law supports this premise. Section 1, Clause 1. All persons born or neutralized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Clause 2. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States. Clause 3. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 1, Clause 1. All persons born or neutralized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. This clearly creates a de facto dual citizenship status, never existing for the sovereign state national. The definition of dual citizenship. Citizenship in two different countries, status of citizens of the United States who reside within a state. Persons who are born or neutralized in the United States are citizens of the United States and the state wherein they reside. Black's Law Dictionary, 6th edition. The definition of neutralized. To grant full citizenship to one of foreign birth. American Heritage Dictionary. Prior to the 14th Amendment, citizens of the United States meant a citizen of one of the United States of America. However, this was not defined by Congress. Because this phrase is now used in the 14th Amendment that sets forth a specific terminology and can no longer mean anything else other than a citizen of the federal government. A United States citizen neutralized as such at birth without informed consent. Previous court's case law touched on this de facto entity. The citizens of the United States in Ex parte Frank Knowles, California Supreme Court, July term, 1885. In the case, the court stated that there was no such thing as a citizen of the United States. That is to say, there was no such thing as a citizen of the federal state, only a citizen of one of the United States. This section 1, contemplates two sources of citizenship, and two sources only, birth and neutralization. The persons declared to be citizens are all persons born or neutralized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject, in some respect or degree, to the jurisdictions of the United States, but completely subject to their political jurisdiction and owing them direct and immediate allegiance. The source of the case is Elk versus Wilkins. That's E-L-K versus Wilkins. W-I-L-K-I-N-E-I-N-S. 112 U.S. 94, 1884. The use of the words there and them indicates a de facto power created to be above the Israelite American people, something no Israelite American willingly accepts and no organic law supports. And whereas it is claimed that such American citizens with their descendants are subject of foreign states foreign to the United States, owing allegiance to subject to governments of the state thereof, and where it is necessary to the maintenance of public peace, that this claim of foreign allegiance should be promptly and finally disavowed. Preamble of the Exportation Act. Case law prior to 14th Amendment passage should indicate no such legal requirement exists, but is what they want all de jure citizens to do. For it is certain that in the sense in which the word citizen is used in the federal Constitution, citizens of each state and citizens of the United States are convertible terms that mean the same thing. For the citizens of each state are entitled to all privileges and immunities of citizens in the several states. And the citizens of the United States are, of course, citizens of all the United States. 44 Maine 518-1859, Hathaway J. dissenting, italics in original underlines and C's added. Case law after passage of the 14th Amendment quite clear that that there is a citizenship of the United States and a citizenship of a state, which are distinct from each other and which depend upon different characteristics or circumstances in the individual. Slaughterhouse cases, 83 U.S. 36, 1873. The first clause of the 14th Amendment made Negro citizens of the United States and citizens of the state in which they reside, and thereby created two classes of citizens, one of the United States and the other of the state. Corey E.T.A.L. versus Carter, 48 IND 327, 1874. Head note 8, emphasis added. We have in our political system a government of the United States and a government of each of the several states. Each of these governments is distinct from the other, and each has citizens of its own. U.S. versus Quirkenshank, 92 U.S. 542, 1875. Quirkenshank, that's spelled C-R-U-I-K-S-H-A-N-K. Emphasis added. One may be a citizen of a state and yet not a citizen of the United States. Thomas versus State, 15 IND 449, Corey versus Carter, 48 IND 327. McCarthy versus Fruelke, F-R-O-E-L-K-E, 63 IND 507, in Welts, W-H-W-E-H-L-I-T-Z, 6 Wis 443. McDonald versus State, 90 IND 320, 323, 1883. We sovereign Hebrew Israelites, de jure American nationals, apply for no such dual citizenship of the insurgent United States de facto government, created about the time of the so-called Civil War, which was actually an international war against the sovereign nation, a state of the Union, apart from or in addition to our natural-born blood sovereign Hebrew Israelite American de jure nationality received at birth. We Israelites reject such de facto citizenship of the United States federal government and retain our de jure blood sovereign Hebrew Israelite American nationality of the sovereign Hebrew Israelite nation, state in which we Israelites are domiciled at any given time, based on our original blood sovereign Hebrew Israelite American de jure national/state nationality. Law of Nations, Title 8, USC 1101A21. Section 1, Clause 2. No state shall make or enforce any law which shall abridge the privilege or immunity of citizens of the United States. This portion of Section 1 clearly defines that such United States de facto citizens do not have natural rights, but are granted privileges for being such a de facto citizen, thereby removing them from de jure status as blood sovereign Hebrew Israelite Americans nationals of their respective states, including all natural rights such as sovereigns would otherwise enjoy. Governments do not grant natural rights, it is to uphold them. All neutralized citizens of the United States, while in foreign states, one of the several American republics, shall be entitled to and shall receive from this government the same protection of persons and property that is accorded to native-born citizens in like situations and circumstances. Exportation Act, Section 2. The term foreign states includes outlying possessions of a foreign state, but self-governed dominions or territories under mandate or trusteeship shall be regarded as separate foreign states. Title 8 USC 1101A14. This is trying to imply that all de facto Negroes, African Americans, blacks, colored, etc., citizenship slaves of the de facto United States federal government are being given all the same de jure rights that de jure citizens, read non-citizens of the United States, but citizens of de jure states have, but this is not true. As all U.S. so-called Negro African Americans, blacks, colored, etc., citizenship slaves are under the jurisdiction of the United States, states federal government, and all its Roman civil law color of laws. These privileges and immunities are not the same as the ones secured by the Article 4, Section 2 of the Organic Constitution for non-14th Amendment citizens. Citizens are members of a political community who in their associated capacity have established or submitted themselves to the dominion of a government for the promotion of their general welfare and the protection of their individual as well as collective rights. The citizens cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres must pay the penalties. U.S. versus Cruikshank, 92 U.S. 542, 1875. That's Cruikshank. U.S. versus Cruikshank gives us reason why blood sovereign Hebrew Israelite American nationals in disguise as so-called Negroes, African Americans, blacks, colored, etc. are being murdered with impunity, legally. These citizens cannot complain because he has voluntarily submitted himself to such a form of government. 14th Amendment states dependencies of the federal government and as such colonies of the same. The definition of colony: a dependent political community consisting of a number of citizens of the same country who have immigrated therefrom to people another, and remain the subject to the mother country. Territory attached to another nation, known as the mother country, with political and economic ties. Possessions are dependencies of the British Crown. Original 13 colonies of the United States. The Nationality Act of 1939, Preamble, Title 8 USC, and the Title 22 USC all set forth two different jurisdictions. The de jure jurisdiction under the Constitution and the de facto jurisdiction under the 14th Amendment. Upon birth under 14th Amendment rules, all blood sovereign Hebrew Israelite American nationals disguised as so-called Negroes, African Americans, blacks, colored, etc. are fictional by paper birth certificates transported to Washington, D.C., then fictionally by paper birth certificate transported back to the state wherein they reside.